2 reads as follows. Measures adopted by the heads of court to curb the spread of COVID-19 in all courts. It's dated today, the 17th of March, 2020. Directives issued by Chief Justice Mogoeng Mogoeng in terms of Section 83B of the Superior Courts Act 2013. Whereas on Sunday, 15 March 2020, Cabinet decided that one gathering of more than 100 people will be prohibited, and where small gatherings are unavoidable, organizers will need to put in place stringent measures of prevention and control in order to curb the spread of COVID-19 in South Africa. Now, therefore, the heads of court have decided to adopt the following measures. 1. Persons with a material interest in a case, such as litigants, accused persons, witnesses, those who may be needed to provide support, such as those accompanying children, victims of domestic violence and/or sexual abuse, elderly and people with disabilities, family members, representatives of special interests or support groups, and members of the media will be permitted to enter the court precinct. 2. All court buildings shall be secured to avoid exposing judicial officers, court staff, and members of the public to risk. To that end, the following measures shall be put in place. A. Decontamination of reception and admission areas, community service centers, courtrooms, cells and detention facilities, offices, lifts, vehicles, biometrics, and ablution facilities, and all other objects that are generally touched by persons utilizing the facilities, including handles and taps. Floor and work surfaces of courtrooms and the premises, as well as workplace, with special focus on maintenance and domestic violence, children's court, be disinfected with disinfectant material periodically, at least twice a day during working hours. C. Assignment of officials who will sanitize hands of officials, including service providers, persons in custody, inmates and visitors at all entry and exit points. D. Installation of secured alcohol, ethyl alcohol 70%, based sanitizer dispensers at all points of entry, exit, workstations, and in the passages and corridors. E. All officials at reception, admission, and operational areas shall be issued with appropriate protective equipment, that is, heavy-duty gloves, disposable gowns, N95 masks, protective eye shields, etc., as per the Department of Health standard operating procedures. F. Gloves shall be sanitized between searches. And G. Handheld infrared thermometers or scanners shall be made available to conduct the temperature screening of judicial officers, staff, and members of the public. H. Provision and disposal of biohazard material. 3. The executive shall avail the necessary resources to ensure that access to justice is enforced in line with the principle that justice shall not only be done, but must manifestly be seen to be done. 4. The Department of Health, with the coordination of the Minister of Justice and Correctional Services, shall conduct assessments of the preventative measures at courts. 5. It is imperative that all court buildings have running water, toilet paper, soap and disinfectant wipes, and all other relevant health and safety material. 6. A distance of 1 meter shall be maintained between people seated in a courtroom. 7. Judicial officers and court staff must self-isolate and seek medical intervention if they display any symptoms. This also applies to those judicial officers and staff members who have traveled to high-risk areas or have been in contact with a person who has recently traveled or displayed symptoms. 8. The judiciary will be making proposals to the executive for the need for the judiciary in line with Section 165(6) of the Constitution and their powers in the Superior Courts Act to issue directives for courts and courts operations. 9, the judiciary urges all to comply with the directives and guidelines issued by the relevant departments when dealing with confirmed or suspected cases of COVID-19. The last bit of the statement that does not or cannot be attributable to my colleagues but is mine is the following. I think we're facing a challenge that all of us would do well to do everything within our power to confront with the capacities that we know are bound to contribute towards the attainment of that objective of securing a safe South Africa that is normalized again and permits of free movement and productivity in all walks of life. What we must never forget is our national anthem. Our national anthem is a call to prayer. And so is the preamble to our Constitution. It, among others, say, God protects South Africa. We are exposed. We are not protected. And my call is to all those who can pray to see it as an absolute necessity, starting from today, to do so. The preamble goes on to say, may God bless our people. We need not to be as cursed as we appear to be by this virus, but to be blessed. We need an economy that is flourishing. We need normalcy to shake hands and hug as is normal. And those who know just how powerful prayer can be, I plead with you from the depth of my heart that at least every Wednesday and every Sunday, go out there in groups that do not exceed 70 to pray, knowing that with prayer, nothing is impossible. I know others may reduce these remarks to something to be mocked at, but you know the potency of what I'm appealing to you to do. The church cannot afford to be running helter-skelter as it appears to be doing right now. It is time for you to demonstrate the power that you have been preaching about, the power that you have been talking about, by identifying all kingdom-minded people, and cry to God for the sake of this country, for the sake of the continent, and for the sake of humanity. I'm now open to questions, and all questions, because I know that there are certain questions that you have literally been dying to put to me that are unrelated to what we are here for. I said to Mr. Ngube, I'm here. In case you thought I was running away, you've got me now. I'll deal with all your questions until you have no questions to ask anymore.
There you are, colleagues. You've heard it. By show of hands, I note Griselda, Karen, and my lady in that order, and then we'll come back there at the back. Let's start.
Good afternoon. I'm Griselda Lewis from SABC Television News. Chief Justice, good afternoon.
Good afternoon.
You've been very vocal about many things in society, including how South Africa handles certain challenges. I think this is a world challenge. Would you say you're satisfied with the way that, I know you've put in measures now as the judiciary, but would you say are you satisfied with the way South Africa has handled the issue relating to the coronavirus? And since you're open to all questions, I have to ask, Chief Justice, have you received a letter from the 10 judges who are refusing to preside over the matter with their colleague Judge Mushtaq Parker? Are there any interventions that you're taking at this stage? And what is the impact of this entire debacle on the integrity or the perception of the judiciary? Will any of them be placed on special leave until this debacle is over? Thank you.
Well, maybe if I deal with your question, it will actually eliminate others or reduce them. Let me do that. I think it would be inappropriate for me to make any judgment call on the measures made by the other arms of the state. We've never been here before, and none of us should, from the vantage point of an armchair critic, pretend that they have all the answers to this altogether new challenge that our country and the world has never been confronted with. I think it's enough for me to say the executive arm of the state has done what it considered to be appropriate to do, and ours is to throw our weight behind them and creatively find additional measures that does not compromise the hygiene of fellow citizens, that does not undermine the capacity to deal with this problem and be supportive. So it's not for me. It would be highly inappropriate of me to pretend that I'm the smart guy who has solutions to challenges and others are just too dumb to find out the obvious solutions. So I think they've done their best. We've got to do our best and support this effort collectively to drive towards an acceptable state of health in South Africa. Now, let me deal with this issue, because a lot has been said about the impact of what is happening in the Western Cape on the integrity of the judiciary. And some have not actually been honest in dealing with this issue. I'll tell you why. Anybody who is able to read must, before criticizing, make it his or her business to find out what powers the judiciary or the Chief Justice has. It is highly irresponsible and disingenuous to pretend that the Chief Justice has powers that he doesn't have. I don't have the power even to grant leave of any colleague. I don't even have the power to grant myself leave. So to suggest that the Chief Justice ought to have placed any of the judge against whom allegations are made on leave is highly disingenuous. Where does the laziness come from? Why can't we just find out what is the regulatory framework in relation to leave or the suspension of judges? And based on that understanding, begin to communicate with the nation. I say it because it's highly damaging of the integrity of the judiciary to lazily or in pursuit of an undisclosed agenda, to suddenly communicate with the nation as if there is this talkative Chief Justice. He's always talking about things that do not even fall within the confines of his area of operation. Now that chickens have come home to roost, he is now just hiding away from the media. He is unable to deal with the issues that he ought to be dealing with. Let me put this to rest, and I hope I'm putting it to rest because it's not the first time that it was put to me. And let me start it this way. When you establish institutions that are critical to the functioning of our constitutional democracy, we ought to make sure that all the capacities necessary for those institutions and constitutional office bearers to function effectively are given to them. That is not the case with the judiciary. In the judiciary, none of us, not even as a collective, can shift any of our employees that we consider misplaced in whatever court he or she finds himself. I can't, for instance, discipline any colleague. The best I can do, which I know how to do when circumstances permit, is to beg. So I don't have the power to suspend or to put on leave anybody in the Western Cape. There is a framework, though. The Constitution says it is open to the Judicial Service Commission that I chair to recommend to the President to put a judge on suspension under certain conditions. But how does that work? It all begins with a complaint being lodged with the Judicial Conduct Committee. And once evidence has been looked at and a determination made by that structure that this is a likely impeachable offense or an offense that makes it difficult for a judge confronted by those allegations to function properly at court level, then they make a recommendation to the bigger body of the Judicial Service Commission that excludes members of parliament to ask the Chief Justice to recommend to the President to put a judge on suspension. So it will be, expediency often demands that to look smart, to look decisive, just do it. They will clap hands for you. But the consequences will be dastardly because people will challenge you in a court of law and you'll be embarrassed as a lawyer for doing things that are contrary to the law. But there is also something else. People have been writing to me saying, yeah, you see, you people have taken forever to finalize the first John Thorpe complaint. Well, the question is, what could have been done? That matter came in when Chief Justice Langa was in office. It came in, it was still there when Chief Justice Ngobo was in office. I now found it here. What is it that can be done? There is a very dishonest assertion that even when colleagues are challenging the regularity of the structure that has called them to answer for cases of misconduct, it is open to the Judicial Service Commission or to the Chief Justice to say, forget about due process. You are a judge, you shouldn't be enjoying the rights that everybody else enjoys. It doesn't work that way. We have as one of the foundational values of our constitutional democracy the rule of law. And in the rule of law is a principle of legality. And the principle of legality does not allow any one of us to exercise power that he doesn't have. I don't have the power. The Judicial Service Commission does not have the power. When judges are challenging proceedings before the courts to then proceed as if nothing is happening, none of us has that power. So when you criticize the Judicial Service Commission and calling it by whatever name or its processes, just know that democracy is a very complicated process and it can also be very frustrating. We are not going to flout any of these guiding principles, even in relation to the new cases. I would be lying to you, trying to solicit a favorable response. If I say to you, even the new case will be dealt with speedily, I don't know. I can't be predetermined. I don't know whether people are going to choose to challenge us in a court of law or not. So whatever perspective you have, know that we respect the laws. And that is why, unlike many or some arms of the state, where people's decisions will be challenged and overturned over and over again, we're not in that space. We falter occasionally. Why? We make sure that the rules are followed. 10 judges, I heard about the 10 judges. I have not yet been given the letter of the 10 judges. But let me tell you what will happen if it is true that 10 judges have written a letter in the terms that they have. My understanding from rumor is that that letter is designed to file a case with the Judicial Conduct Committee. Why? Why are they not filing a case with the Chief Justice? They know I'm powerless. I have for many years been saying the judiciary is not appropriately capacitated, unlike Parliament, unlike the executive, to, for instance, put on leave whoever needs to be put on leave, to suspend whoever needs to be suspended. We are hamstrung. And sometimes it gets too frustrating because you have a sense of what you should be doing to protect the institution, but you don't have the power. That's the challenge. And when we said that, nobody supported us to say, but this is right. This institution must be strengthened given the critical role it plays. Some said this man is hungry for power. Now he wants more power. He's not happy with the power that he already has. That's where we are.
Thank you, Chief Justice. Karen?
Just two questions. The reality is that the courts oftentimes are in horrific condition anyway. The bathrooms in the court, the water, they're very debilitated. So where are you going to get the funds to jack up on the sanitation? Is Justice providing it to you? What's happening there? And how urgently is that going to happen? There are also grave concerns because of the prison population and the risk of infection. Are you considering potentially
Oh,
having
I didn't pick it up.
with inmates, that there's a pronounced risk of a corona infection in that environment. Are you considering, for instance, doing cases remotely by camera, etc.? And then on the Shlobe issue, yes, there was a pronounced level of litigation attached to that matter, but I think that ended about 2 years ago. And the delay around the first 2008 complaint seems to be around the issue of funding of his lawyer for the last 2 years. The unfortunate reality is, and I'm sure you're aware of this, that because of the pivotal role that the judiciary plays in oftentimes making decisions about government malfeasance, governance issues, you are particularly vulnerable to criticism that when it comes to issues of accountability within your own ranks, you're not actually taking the action that you need to, just in terms of that 2-year period. And then you were saying in terms of that letter that it was designed to potentially be a complaint to the JSC. The unfortunate reality is that you now have a situation where multiple judges are literally releasing media statements. The stuff is coming out. It's very, very ugly and it's very damaging to the Western Cape High Court, which is one of the pivotal courts in this country. I mean, how does this matter get resolved? Because if, as you say, and I'm not arguing with you, that there is limited power, they can't really do anything. What do we do then? Who solves this problem? Who's accountable for it? Because the situation cannot continue. It can't be the judges are not prepared to sit with each other, that kind of thing. Thank you.
Well, thank you so much, ma'am. There was litigation, but even as that litigation was proceeding, some commentators kept on condemning the Judicial Service Commission and indirectly the Chief Justice as if there was something they should be doing which they are failing to do, and deliberately. I'm saying that appears to have been highly disingenuous. Talking about 2 years since litigation. Now, when a judge is facing charges of misconduct, ordinarily, he or she expects the state, through the state attorney, to fund his or her legal representation. And we have been criticized for this 2-year period. We don't fund judges. It is the executive. Why did you not channel your criticism where it belongs? Why did you not speak to the Minister of Justice and to the state attorney and say, why are you not funding these people? Instead, the JSC is a mess, or there is a mess in the JSC, as if there is something that we should be doing that we are not doing. The bottom line is, when you know from the depths of your heart that an institution and a personality does not have the powers, what is it that allows you to tell the public, which, by the way, is what reduces public confidence in the judiciary? You tell the public that the Judicial Service Commission and the Chief Justice is not doing what they are supposed to be doing, when you know. I know of a journalist, for instance. I had a press briefing like this, and this Shlobe thing came up. We explained our limitations. I was shocked when I saw the article. The article disregarded, our incapacitation by the regulatory framework. It went on to say, if there is anything that the JSC and the judiciary can never shirk from itself, is that its integrity is compromised by its failure to deal with the Shlobe matter. When we had made it clear, there was nothing we could do. Now, if I ask of you now, what have you done to deal with a problem in a particular media house in which you are not even working? Or what is it you have done to deal with your editor over whom you have no power? That's an unfortunate question. Expect people and hold them accountable for what is within their power to do, but they are inexplicably failing to do it. You'll never find the judiciary in that space. Now, again, for the purpose of confronting the 10 judges, it's in the public domain. I don't have any power to do anything about it. You know why? The people of South Africa, through their representatives, deemed it necessary to create a structure known as a Judicial Conduct Committee. That is the only way to deal with complaints. That is the only disciplinary mechanism. I could try to be very creative and out of expediency to take the pressure, if there is any pressure. Unfortunately for me, nobody can ever put any pressure on me. I could easily, though, to look like a hero, confront the situation in line with comments out there. There will be an applause for a while. But knowing that I don't have the authority to do it, that's going to frustrate the process even more. The best that I can do is to keep inquiring from judges who serve in the Judicial Conduct Committee, not instruct them. Colleagues, how's progress there? I'm entitled, even as a member of the public, to ask. Do whatever you can to speed up the process. That's the best I can do. And that applies to the 10 judges that have written a letter. The best I can do also is to just have a meeting with colleagues, knowing that I'm powerless. In fact, it is open to them to ask me, oh, what are you here about? Quote as the section in terms of which you are here, to do that which you think you can do. That's how weakened the judiciary has been by the regulatory framework around it. My colleagues will add, they are here. They will add where they believe something needed to be added. As regards where the funding is going to come from, it can only come from the executive. We had a meeting, all of us here, the leadership of the higher judiciary, the regional courts, and the district court. They are here. We had a meeting with the Minister of Justice as a member of the executive to say, look, how to regulate issues around courts, it's our responsibility. It's in the Constitution, it's in the Act. Your responsibility as the executive is how to make resources that are necessary to keep the environment comfortable and hygienic for everybody. So tell us now, I heard you say yesterday that the Disaster Management Act allows you people, when operationalized, to release resources that would otherwise not be released. Are you going to make money available to us? He said, well, I can't commit to a figure. I said, as a matter of principle, do you make a commitment to make sure that courts are kept in a state that we say it ought to be kept in? He said, that principled commitment I can make. That's where it is. So we trust in the executive to make the resources available. And also, as Minister of Correctional Services, we said to him, it's your responsibility to make sure that as inmates come to courts, all the critical measures have been taken to make sure that they don't come to courts and make the situation more difficult than it is. We said, for instance, the police who have to handcuff them, have to touch them. Do they have gloves? The police have to speak to them at close range. Are there masks for both the police and for inmates? The interpreter who must sit next to an inmate, because some of them do need interpretation services or language services as they are called. They've got to have a mask. You can't suddenly be too far from the person that you're supposed to talk to. What resources are being made available to us? And we said to him, some of our colleagues have creatively used the petty cash to buy sanitizing material, to buy masks, and to buy gloves, especially for the security personnel. And we would want a commitment that at least at the level of petty cash to make this thing, to keep this thing going, there is a commitment. He said, no, the director, he called the Director General, the Acting Director General to speak. He said, I will make 5,000 to every court available as petty cash, and obviously, as and when we run out of that 5,000, we can requisition for more money. That's where it is. But I don't want to be a lone voice. Colleagues, anything from you? Yes.
Thank you, Madam.
Hi, Chief Justice. If you can just clarify, some court staff are saying, some courts are saying they will not run other matters, but will only postpone them and have only urgent matters. And is there a timeline on when all of these measures will start being implemented? When can people expect to get into a court and these measures are implemented?
There is no measure that will apply to any court in this country that is inconsistent with what we have announced here. What must be understood is that colleagues, out of a sense of responsibility and out of concern for the public, went ahead of this meeting to try and put in place measures that they thought would be appropriate to secure the health of court staff and members of the public. Now, based on this meeting, it's a common understanding all over South Africa now that to the extent that some measures may have been publicized that are in conflict with what has been said here, that part of the measures that, or those parts of those measures that are inconsistent are null and void. And colleagues have undertaken, some of them this morning, that had already out of care taken those measures, have undertaken to take out those measures that prohibit, for instance, members of the public from coming to court and cases from running as normal. And this is what informed our decision in that regard. We don't know for how long this challenge is going to be there. There is no guarantee that it will be over by December. We don't know. So whatever we do must be structured in such a way as to render court operations sustainable. So if you're planning for weeks, then you're going to shut down the court because you think after 3 weeks the thing would have disappeared. That's a bit myopic. So we've got a long-range view of how to approach court operations, and that is why we've crafted the measures that we've read out to you.
Chief Justice, Madam? Yes, please.
Bernadette Works, the citizen. Chief Justice, just a point of clarity that I wanted to ask you about. So you began the statement that you read out at the beginning of the briefing, talking about how people with a vested interest in matters would be allowed into the court. It might sound like a bit of a stupid question, but on the flip side of that, does that mean then that, for example, sometimes we have like large groups of NGOs, etc., coming to court, sort of for observational purposes as spectators? Will that still be allowed to continue? And then if not, I just would like some sort of commentary on, obviously I would assume that it's balancing up different priorities, but how that impacts sort of the open justice principle. Thank you.
That's a very powerful question because it actually is foundational. What informs it is foundational to the position that we have taken, that you can't confine court attendance to accused persons, complainants, and witnesses. We, as we indicated in the statement, that fundamentally justice must not just be done, it must be seen to be done. You take a case like that of Pastor Omotoso, the public wants to know what is going on there. And in circumstances where some people find it easy to accuse the judiciary of corruption and lack of transparency, you don't want to exacerbate the problem by keeping everything to yourself and the legal representatives. Therefore, our position is, in circumstances where you would have, say, a political party's women's wing coming to support a woman who is a complainant in a rape case, for instance, and you have special interest groups, some NGOs that are passionate about the particular case because it falls within their area of responsibility, and also family members. Our position is, look, under those circumstances, to avoid breaching the 100% rule, make sure that you have each group identify representatives. You can say this political parties, women's league have 1 or 3 members or whatever number the judicial officer might deem appropriate. NGO, can't you cut down your members to this? The media must be there. Just imagine if the media were not to be allowed. You people would be fighting us because you must inform the public about what is happening, and if there is something to criticize us about, that's an opportunity you must have to be able to criticize us. So courts will run as normal, except that the limit will not be exceeded. People will be represented. Family members must be there to support their loved ones, whether it's an accused person, whether it is a witness, whether it is a litigant. The only thing might be we might have to reduce. We might have to reduce the number of representatives for each grouping. Yes, ma'am.
Sorry, again, just for clarity, so is what you're saying that the 100 people limit, that we're going to keep to that in individual courtrooms?
Yes, ma'am. Yes.
Okay,
We
so
want.
there
We
won't
want.
be more than 100 people?
No, we won't flout that. We won't flout that.
Okay,
Yes.
thank you.
Thank you. Colleagues, I don't see any hands. Are we exhausted? Okay. Can't see from behind. All right. Maya,
Hi, Chief Justice.
Hello, ma'am.
Shoots from Crown. Nice to see you again. We've seen other spaces such as New York and Seattle put a specific suspension on evictions because we know more people are staying at home, perhaps they're out of jobs and things can't run as normal. Do you have anything to say specifically on the execution and the giving of evictions?
Evictions.
Yes.
I'm not sure I understand.
Yes, eviction orders.
Evicting who?
Anybody from particular places or particular houses. We've seen other spaces in the world put bans on this or put suspensions on evictions. Does that make sense?
No, you mean eviction? Let's say eviction like you come to my house and I don't want you there because you are irritating my family. I want you out.
No, large scale evictions. For instance, if people are squatting in a place they're not allowed to be, or if there is an argument about a specific space. We've seen that happen, for instance, with waste reclaimers repeatedly in South Africa. So these eviction orders normally go through the courts, of course, but right now it could cause complications. So I was wondering if you had put any particular thought to that.
No, I haven't put any particular thought to that, and I don't think I will put any particular thought to that except at a high principle level. Whenever the need arises from the point of view of a litigant or the property owner to have people evicted for whatever reason, we expect the normal course of litigation to be followed, and for any presiding officer handling that matter to apply the normal principles. It may well be that as part of doing so, it would be necessary to factor into the decision-making process how many people ought to be allowed to gather at a place. Say people want to protest. Say they want to protest against the Chief Justice or the President or the Minister. You can't say these Disaster Management Act suspends the right to protest, but you can say it only allows you a particular number, for instance. It may well be an issue that you want to factor in your reasoning as a judicial officer. So it'll be business as usual in that context. But I can't make a pronouncement in advance as to precisely how it is to be handled.
So, CJ, just to clarify, you're basically saying at this point that there will be no shutdown of the court
No,
system.
no,
Is there any circumstance under which you would review that decision?
absolutely.
And have you been, what are those circumstances? And has there been any kind of overture towards you by the executive to say, listen, can you consider shutting down? Or has that not been on the table?
No, that is not on the table. But look, let me tell you, and I don't know for sure, you know, it's always very difficult to speculate, but let me venture into that arena. If the situation were to arise where, God forbid, coronavirus has covered millions and millions of South Africans, we would have to reposition ourselves there based on the advice by those who are in the medical space. We will seek counsel. Part of what we have done, we said to the minister, look, you are here representing the executive. What we want you to do is to please go and speak to the Minister of Health. Find out if they can't identify at a national and provincial level people that we can liaise with as and when we are not sure whether the implementation of our measures could compromise the health of our customers, so that we don't have to wait for some statement to be made by somebody elsewhere. We just want to be able to change speedily. And that is why it's critical, by the way, that the directions that govern the court space are made by the judiciary and not the executive, because we function there. We can see what is happening and be able to respond quickly. But imagine if some member of the executive, maybe the Minister of Justice, was to be responsible for the directions. You must now write him a letter, and he must now take advice from his people. And it was going to be a prolonged process that could jeopardize what you were trying to secure.
Ben?
Chief Justice Barry Bateman from ENCA.
Yes.
Just a quick question on the announcement made by President Ramaphosa. The question of perhaps constitutionality in relation to freedom of movement. There hasn't been a state of emergency announced. What power does the President derive to issue these kind of directives, the elimination of people and so on? Any thoughts on that?
He hasn't declared a state of emergency. He has, as I understand it, sought to put into operation the provisions of the Disaster Management Act. Now, you would recall that whether it is a state of emergency or the Disaster Management Act, whatever they do may be challenged before us. So it would be most inappropriate for me now to run ahead of myself and say, should they dare, this would be the consequences. Let's sit back and wait if people would want to assert their rights and what the right position to be adopted by the courts would be at that stage.
Thank you, colleagues. I can't see any other hand. I'm looking around. Okay, finally, there is one there. Please come forward. You identify yourself.
No, thank you. I end up from Eyewitness Media this afternoon, Chief Justice. Very quickly, I understand that the funds are going to be coming from the executive. Have you been able to quantify as yet how much it would be to introduce all the measures you've announced at the beginning of the week?
Remember, we met for the first time today, and the President made an announcement on Sunday. I would be surprised if they, being the engineers of this move, have been able to quantify what it would take to deploy the necessary resources to contain this challenge. We haven't been. We only met today, and though we've got our administrators available here, we haven't been able to quantify that. What we take comfort from, though, is that we would be able to buy the critical necessities with a petty cash available. And what the disaster management does, for instance, I would imagine would be, assuming that there's still something in the kitty for my travel allowance for the judiciary as well, it could allow us to say, okay, no more traveling. Now that money that ought not to be spent on anything else but traveling could then be channeled to make, what we need to keep the public safe available. So we haven't quantified as yet.
Thank you, Chief Justice. Zelda? Just use the microphone in front of you.
Zelda Fleet,
Yes, ma'am.
Chief Justice, I just want to know, how would some of these measures be enforced? For instance, the sitting meter part. I was, for instance, in the urgent court this morning, and it was like packed like sardines in Pretoria.
Yes.
Will somebody oversee that your measures will be put in place?
Yes. You see, it is the primary responsibility of the head of court at magistrates level, and especially the chief magistrates and cluster heads who are here and those who are not here, the regional court presidents, the judges' presidents, and any other head of court to make sure that moving from here, all measures necessary to implement what we have agreed to are in place. Happily, the Secretary General or Director General for the Office of the Chief Justice, Ms. Message is here. All those people that are deployed in the courts, who are not judges, who are not magistrates, except of course for the magistracy, they fall under her jurisdiction. So it's her responsibility, together with Mr. Mncube, to make sure that there are people charged with the responsibility to help people sit in a manner that does not compromise their own health. You would, for instance, know that in the Johannesburg High Court, Pretoria High Court, the lawyers alone at, what do they call it, roll call, could be anything around 150. But what we have been told, and we still have to verify it, is that if you have the scanner, for instance, if you have the gloves and the masks, that may not be such a problem. I don't know. We'll still verify that. If you have sanitizers, we're told that may not be a problem. But we won't take a risk. Our own principal stance is not more than 100. And if we receive advice to the effect that an exception be made with lawyers because of necessity, they have to all be there, we will do so. What could be done in the interim is, for instance, have a plan with the lawyers in the cases to say, unlike before where you would all be in a court, because we can't be more than 100, we will have either batches of 50 lawyers, we deal with your cases, 50 lawyers. That way we would be able to deal with the cases without compromising the health of the players in the court, in the court system.
Thank you, Chief Justice. Colleagues, I feel like I'm probing you to ask, but if there are no more questions, I think this is where we end. Thank you so much, Chief Justice and the judicial member.
Let me just thank you, good people, for having come. I hope you are taking measures. You seem to be closer than has been recommended, but it's fine. You are not the only ones. Look at us. Thank you so much.